The Supreme Court has been of supreme interest in the wake of the death of Justice Antonin Scalia this weekend. And ironically, Friday afternoon, I had the chance to sit down with Justice Stephen Breyer and talk with him about his new book, The Court and the World, American Law and the New Global Realities. I began our conversation by asking him to detail those new global realities.
The realities are what sometimes goes by the name of globalization, interdependence, words that for the most part sound to me like buzzwords. So I thought I'd explain what they mean rather concretely, because I've seen the number of cases, while I've been on the court more than 20 years, increase tremendously the number of cases where you have to know something about what's going on beyond our shores. Whether it's law or practices or copyright or security, all kinds of things, in order to get the right answer to a question about American law. Maybe 10 or 15% of our cases now. That's the reality. And the question is, how do we respond to that fact about the world?
Justice Breyer, thus far, the court has dealt on two occasions with the Affordable Care Act, aka Obamacare. I know you probably don't want to comment on the specifics of the case. However, I'm curious about legislative intent and trying to understand what Congress meant in the first place with enacting legislation.
We're leaving Obamacare out of it. I would say that the best way to find out how to interpret a statute is often, not always, but often, to find out what is the purpose of the statute. And in that sense, I would look at Congress's intent. When in law school, we learned about the following imaginary case. There is a sign in the park which says no vehicles allowed. Now, does that mean you could not put a Marine Jeep on a pedestal in order to commemorate World War II? It's a vehicle, after all. To answer the question about what the sign means, you have to look at its purpose. And to look at its purpose is to look at the intent of the people who wrote it.
Part of the new reality we face are those who are bent on our destruction, who may not come from other nation states, but from factions and new geopolitical subdivisions. How do we ensure liberty and at the same time provide for security?
Now that is a very good question. And I wish I could tell you that my book answered that question. What it does tell you is I think the key to the question was in one of the four cases concerning detainees at Guantanamo. There are four detainees who brought four cases in our court against the President or the Secretary of Defense, and they won each of those cases, the detainees. And the key phrase, in general terms, in my opinion, was Sandra O'Connor's, which I joined, which says the Constitution does not write the President a blank check to circumvent civil liberties, not even in wartime. That's basically what she said. And once you agree to that, and why agree? Because the alternative led to all kinds of horrors.
Justice Breyer went on to define what he meant historically speaking, specifically the internment during World War II of Japanese Americans who were legal citizens and not a part of Japan's war machine. While most of us agree that we don't want to see something like that repeated, what concerns me about post-9/11 cases in recent years is the legal status our courts conferred upon prisoners at Gitmo, in essence, giving them legal standing to seek redress in American courts. It seems far more reasonable to me to designate all the prisoners at Gitmo as enemy combatants. Such a designation rightfully places them under the rules of war rather than the jurisdiction of our civilian courts. As to Justice Breyer's fondness for the expression found in the opinion of Justice Sandra Day O'Connor that we don't want to give our president a blank check, I would simply note the observation of a liberal justice writing a 1963 opinion. Justice Arthur Goldberg opined that our Constitution is not a suicide pact. We'll be right back.